I think the idea behind that was because with a formal document that gets rid of any doubt and dispute as to whether the parties have come to an agreement. Is that correct?
That's
Whereas,
right, yes.
With emails and other forms of communication, it's a bit hard to do that.
Yes.
But now I saw in the Instruments Act that you were referring to that there's another a subsection within that 126 saying that if you've done it by email, your electronic signature is your signature. So that's made it a little bit more clear in terms of emails, right?
Yes, there are, as I said, there are a number of laws, regulations, acts, Commonwealth and state governing this situation. So, as I said, so it's not one. But this specific signature is actually covered by certain regulations to facilitate electronic commerce and take into consideration the new technology.
I presume it's just interesting to think that we're going to a digital age where you can actually sell your house via an email or some form of electronic signature. It seems all a bit hard and fast.
Well, we are not saying at this stage that you should try to sell your house using an email, Craig. You have to exercise extreme caution. It's just that in this situation, as the case has indicated, it was accepted by the courts that there was an agreement. Again, one of the arguments is the Instrument Act, and they say this cannot be because it didn't follow the Instrument Act in that state. However, Victoria, we have got a particular section in the Instrument
Section
Act.
126?
You are right, Emily, yes. And although this is not a Victorian case, the judgment slightly differs. The judgment was, in the circumstances where the parties have engaged in negotiation by email, in particular where an offer is made by an email, then it is open to the court to infer that consent has been given by conduct of the other party. So this is one aspect, but the need for it to be in writing, I guess you can always argue that email or a text that's in writing. But I wouldn't be at this stage would give any green lights or indications or advice to any party to sell your house just using an
well, let's be fair, it's a good little test case for a young lawyer.
Oh.
So what I think our viewers and myself can take away from this is if I don't want my email creating a contract, then I make it very clear in that email that I want the contract to be in physical form and physically signed by me, unless otherwise it won't be enforceable. Is that correct, Dinesh?
It is not completely incorrect. You must make it very clear that whether you want to be legally bound by that or not. Now, an email, if the intentions are understood to be the intention to create a legally binding document, it will, without a formal written agreement or a document. The email itself sometimes can be argued that it is a legally binding written form, or the other side may obviously say no. But the intention here, or to protect yourself, you must clearly say whether until a formal document is executed, you or I or we do not intend to be legally bound. That's the essential part.
So what? One follow-up question in regards to contracts. What if I start performing the terms so I didn't exactly agree to the contract? So say you said, Craig, paint my house, and I didn't say I agree, I just started painting your house. Does that contract start? Or
maybe. It depends on the final arbitrator, so to speak. Typically lawyer-like answer, I guess, I'm giving here. Well, you could just perform things as and when you wish. That does not mean that you have performed it under a contract. And on the opposite side, they may say, you have just gone and done these things. We didn't intend to be bound. So it depends on the exact facts of the matter.
Everyone's case is a little bit different.
Case by case analysis.
Yeah.
So Yvonne, what is our number one piece of advice today in regards to contracts?
Well, just remember it's extremely important and be very clear that if you do not intend to be bound by the result of your ongoing negotiations with the other party, then state clearly in your email or whether in your text message or whether just by verbally until that you want to be bound and put it in writing and signed by both parties.
And Dinesh, what about you?
Always I suggest to put it in writing. Nothing should be in verbal. You could have discussions, but soon after that turn it into a written format, either through email or maybe text these days, either through Skype, I don't know, but put it in writing. Secondly, as Yvonne said, emphasize the fact, because in this particular situation now we understand the importance of having that particular intention, to put it in writing. Otherwise, without you knowing, or you could be forming a legally binding contract. I would also strongly suggest, if the matter is quite important, if there's a lot of money is involved, to avoid any issues, get professional advice, do it properly. In most business purchase or sales situations, we have seen sometimes parties just agree verbally or among themselves, just exchange few emails and form a business sale sort of situation, sometimes without the lease. So exercise caution and get professional advice.
So I presume this raises our mantra of Law Help Australia that we normally say at the end of an episode. If you have an issue or you feel like that you're executing a contract, seek legal advice, because they're going to give you a better perspective than anyone out there.
So that's all the time we have for today. I'd just like to thank Craig, Dinesh, Yvonne for joining us and for providing all the valuable information that you've learned through these cases. To catch up on all our past episodes, you can go to our YouTube channel or our Facebook page, or even our website, www.lawhelpaustralia.org. If you would like to participate in our program, are a leading community member, a legal practitioner with things to share, please contact us at info@lawhelpaustralia.org. Thank you.